All right, if you're gearing up for the Advocate on-record exam, you already know the drafting paper is a beast. It's where all that theory smashes into real-world high-stakes practice. So what we've done here is distill some incredible advice from a senior advocate at the Supreme Court. Think of this as your roadmap, turning what feels like a super daunting task into a clear, winning strategy.
So here's how we're going to tackle this. We'll kick things off with drafting as a core skill, then we'll break down a universal blueprint for petitions. From there, we'll dive into the special rules just for the AOR exam, look at the common mistakes you've got to avoid, and then how to get that winning edge. And we'll wrap it all up with the single most important takeaway.
Okay, so before we get into any of the exam nitty-gritty, let's just pause for a second. Forget all the templates, all the dense legal jargon. The real foundation of a powerful legal draft, well, it's not just what you say. It's about how you build your argument piece by piece, like a solid foundation.
And this is maybe the biggest mental switch you need to make. Your draft? It's a communication tool. You're not just writing a document. You are guiding the mind of the court. Every single word, every sentence is a stepping stone you're laying down to lead the judge step by step straight to your conclusion. No confusion, no side trips. Okay, now that we've got that core idea down, let's look at the actual blueprint, the non-negotiable structure of any strong legal petition. These are the parts you just have to get right, no matter what.
And here's the flow, the perfect sequence. You start with the provision of law, what's your legal basis? Then, what's the core issue we're fighting about? You introduce the parties, lay out the facts. What actually happened? And then you build your case with submissions and grounds. Finally, you end with the prayer for relief, telling the court exactly what you want them to do.
All right, let's zero in on the AOR exam itself, because this is where things get specific. It's not just about good drafting in general. The exam has its own unique rules, its own little challenges, and you absolutely have to know them. Okay, this is absolutely critical. The synopsis. Think of it as the first thing the judges are going to read. It's your one and only chance to make a first impression. And honestly, it might be the only thing they read carefully. So your best, most powerful issues have to be right there, up front. And here are some of those special rules you've got to burn into your brain. First, master the Supreme Court rules. The CPC doesn't apply here, so don't even think about it. Second, unless the question explicitly tells you not to, you have to draft supporting affidavits. And hey, this one's practical. You're not going to have a keyboard, so practice writing by hand. And finally, every single document, every application, every affidavit needs its own proper title. No exception.
All right, let's talk about the common pitfalls. It's funny, a lot of people don't mess up on the super complex legal stuff. No, it's the simple, obvious mistakes that can totally undermine an otherwise solid draft. These are the things we want to make sure you avoid. And this quote from a senior advocate at the Supreme Court just hits the nail on the head. He said, "These all sound very obvious, but I have seen that people forget because these are so obvious." It's so true, right? Under pressure, the basics can just fly out the window. So let's look at some of these common errors. Vague stay prayers? Useless. You have to be specific about what you want stayed. Forgetting that mandatory denial clause in a counter affidavit? That's a huge red flag. Another one? Writing these long, super complex sentences. They don't make you sound smart, they just make you hard to understand. And please, please, avoid ambiguous pronouns like he or they. It's always the petitioner or the respondent. Be crystal clear. Okay, so we've covered the basics and the common mistakes. Now for the fun part. Let's talk about gaining that winning edge. What are the advanced strategies that can take your draft from just good enough to something that really stands out?
Now, this piece of advice from our expert is, well, it's a little blunt, but it is a total game changer. When you draft, assume that all other lawyers are idiots or judges will not understand. The point isn't to be insulting, of course. The point is to aim for such extreme clarity that there is zero, and I mean zero, room for misunderstanding.
Here's something that trips a lot of people up. The difference between a question of law and grounds. It's actually pretty simple when you break it down. A question of law starts with whether. It's a pure legal issue. For example, whether the High Court misinterpreted Section X. But grounds start with because. They explain why a finding was wrong. And this can be factual, like because the High Court completely ignored the evidence on page Y. See the difference? One is what, the other is why. Want some pro-level strategies? Here you go. First, show that you're up to date with recent relevant Supreme Court judgments. That's a huge plus. But here's the next level. If the facts of your case allow for it, argue that a prior ruling by a smaller bench should actually be reconsidered by a larger one. Now that shows some serious legal awareness and strategic thinking. It's a bold move that can really pay off.
So we've gone through a lot. The core skills, the pitfalls, the pro tips. But what's the one single big idea that ties it all together? What's the final takeaway that should guide every single word you write?
It really all comes down to this one question you have to ask yourself. Are you just completing a format, or are you actually guiding the mind of the court? Because a winning draft isn't just a box-ticking exercise. It's an act of persuasion. You're making it easy, almost inevitable, for the judge to see things your way. And that, right there, is the whole game.